Chair recognizes Representative Vasut.
A few questions. When individuals are married, does each spouse owe the other an obligation to provide, support and maintenance?
You have an obligation to provide for necessaries. Is that what you're asking?
Yeah, I'm trying to. It's been a while since I've been in the family law class in law school, so some of these questions may be softballs, but I'm just trying to lay a foundation here. For example, if a husband and wife are together and the wife gets cancer and has to have treatment, is the husband obligated to pay for that treatment?
Well, it would be a community. It would be a liability that fell on the community.
So both of them would. When it comes to debts, a debt of the community is owed by both. Is that correct?
Well, sort of. It kind of depends on the debt, but in the final division of a divorce, it's going to be included on the spreadsheet, most likely, unless the creditor agreed to look only to the separate property of the person.
If the wife has cancer, goes in for treatment, and she gets the treatment, she doesn't pay, can the creditor come after the husband?
It depends on how they've set up that liability, but
it's possible.
Maybe.
In fact, generally, in a marital situation, you pay for each other's medical care, correct?
Typically. I mean, yeah. It depends, once again, on how that...
Once the divorce is finalized and the ex-wife now is getting that medical treatment after the divorce, the husband's under no obligation to pay for it, correct?
So once you're divorced, all of your assets and all of your liabilities become, it's separated. And so going forward, any debts that you accrue are going to be your own debts.
So the husband is no longer under any obligation to pay for the necessaries of the wife, correct?
Well, not always. You could have a situation where somebody is paying spousal maintenance.
Okay.
And if they're paying spousal maintenance, then they might have some continued obligations to pay for that spouse.
So the spousal maintenance is kind of a calculated figure under the statute right now, correct?
That's right.
Texas does not recognize alimony, right?
No, but it's really similar.
Okay. But generally, what I'm trying to get at is the difference between the relationship of a husband and wife and an ex-husband and ex-wife. While they're married, the husband is obligated to take care of his wife. When they're not, he's generally not. Would you agree that that's kind of a fair summary of the distinction between the two?
I don't think that I would say that the husband is legally obligated to take care of the wife. I would say that as a marriage, that they have that the parties have to supply, provide for necessaries of the other person. But I don't think that there's anything that specifically says that the husband has to be the financial provider for the wife.
The necessaries, though, under law are defined as the basics: food, clothing, shelter, medical care, correct?
I think it's generally assumed to be that.
Yeah, so for all intents and purposes, each spouse, and I'm using one hypothetical, but it can be totally inverted. Each one takes care of the other's necessaries.
What would come out of the community estate, whatever that estate is.
So, what recourse does a wife that does not consent to divorce? So let me lay the hypothetical for you. The husband, while the wife is getting chemo, decides he wants to divorce her because he doesn't want to pay for the chemo treatment. He doesn't want to, have to care for her anymore. So he goes off and files a no-fault divorce petition claiming insupportability. Doesn't claim anything else. What defense does she have to be able to prevent that divorce from going through in order to ensure that she still has the care and provision of the husband for her necessaries? Does she have any recourse?
So the way that the law works in Texas on an issue like this is that she would be able to ask for spousal maintenance. She would say that she has a disability that came about during the marriage. If the disability was prior to marriage, that would be different. But you would say you had a disability that incurred during the marriage and you need continued support. You can also ask for a greater division of the community estate, which is different than other states. Other states have straight 50-50 on property division. Texas doesn't. We have a fair and right division, and they look at the needs of the parties. So she would have an ability to make an argument, assuming that the marital estate has some financial money within the estate.
And what would you say is generally the difference between dating and marriage under Texas law other than the community estate protections? I mean, is there really any difference?
So by being married, you have thousands of rights that are bestowed upon you in all sorts of different codes, from retirement to pension stuff to health care. I mean, it spans all sorts of different codes. Like, there's a reason why people that were same-sex weren't okay with civil unions and wanted marriage. It is a legal issue. And you don't really realize how much marriage affects different things until you start breaking apart those different issues.
And all of those rights for one spouse go away once the marriage is terminated, right?
That's not necessarily true. It depends on exactly which right you're looking at, because some things, like, say, for instance, Social Security, you might still be able to claim a Social Security benefit.
Quadro.
Yeah. Well, no, not just a quadro, like a Social Security benefit after your spouse passes away. And there's certain rules for that. But you have to look at each individual code.
Would it be fair to say, though, that at least some rights terminate at the conclusion of divorce? Because otherwise there would be no distinction between a marital relationship and an ex-marital relationship, correct?
Sure, yes.
Okay. And so when we think about, no-fault divorce and requiring, really what this bill does is repeals unilateral no-fault divorce. Is that correct?
Well, that's not exactly right, because what this bill would do is, unless both people agreed, you would have to prove fault.
So
You would have
when
to
it's
have that.
one person, that's unilateral. When it's two, that's bilateral. You
Sure.
understand that distinction? Okay.
Yeah, of course.
So this bill repeals unilateral no-fault divorce. Now, in order to get no-fault divorce, it has to be bilateral. Both parties have to agree. Otherwise, just like you said and mentioned, one party would have to prove some grounds for at-fault.
That's right.
Okay.
And they'd have to prove by clear.
Would you think, and this is more of a policy question, do you think the problem is that it's too difficult to prove an at-fault divorce, or the problem is that, really there shouldn't be any at-fault grounds? Because you mentioned earlier about the issue of the courts being tied up, and it's very difficult to prove, and how do you prove infidelity, because you have to demonstrate, certain things. And would you think that the problem is not so much so that we have, bilateral no-fault divorce, as opposed to it's just too hard to prove at-fault divorce?
Well, it's not just one problem. There's a number of issues. So frequently, I'll have a client come in to talk to me, and they have adultery, right, that has happened during their marriage. We will start off the divorce and just claim no fault, because the hope is that you can have an amicable divorce, and that you don't air everybody's dirty laundry, that it's easier on the children, that people separate in a peaceful way. Family law can become extremely contentious. People kill each other.
Sure,
they
sure.
can be dangerous towards us as practitioners. So you try to keep things calm. At any time, you can amend your petition and allege fault. So it's not like you have to claim fault right away. So the having to claim fault right away in order to meet certain legal requirements, it increases the animosity between people that are already having very difficult, very emotional times. From the court system standpoint, it's going to be a nightmare. They're not going to be able to handle it. And the amount of pro se people that are trying to do their own divorces right now is really high. They're not going to be able to handle it. They're going to have to put on evidence and cross-examine people and act as a lawyer on complicated issues. And then there are lots of things that happen that you would say this is a reasonable reason to get divorced that aren't falling under any of these fault grounds. You have a spouse who is addicted to meth. Which fault ground does that fall under? You have a spouse who is narcissistic and verbally and emotionally abusive. Which fault does that fall under? You have somebody who has taken off and you don't even know where they are. Or maybe you had a very short marriage. Maybe you got married right out of high school. There's all sorts of things. And you're looking at a state that has 26 million people in it, right? And all these different reasons. And they're very complex. And to add a fault ground that you have to prove, it just makes it all that much more difficult, that much more complex. And it's going to be, I would definitely oppose it as a
Chair recognizes Representative Ramos.
Ms. De La Reza, in a situation, for example, where the wife does have cancer and her husband refuses to pay the medical treatment, I guess my colleague would say that marriage should stay, you know, because the alternative, or in that situation, that woman with the cancerous treatment whose husband refuses to pay now with cancer has to go to court and prove without no fault grounds, right? To prove that I have cancer, I'm dying, he refuses to pay for my medical bills. The evidence would be, I assume in a situation like this, what would evidence be? She'd have to record him, follow him around the house saying, I hate you, I'm not paying your medical bills. What else would, in a situation where there's no fault grounds, the woman's dying of cancer, husband doesn't want to pay the bills, what would be some evidence that one would have to present? The cancerous woman.
That she would have to present if she didn't want to get the divorce?
If she wanted to get the divorce, we eliminated no fault grounds. So now she has to prove evidence of fault.
Right.
That whatever, I mean, it's not financial, stranglehold is not one of the fault grounds, so what would it be?
Right.
What would she have to prove?
So in family law, she'd have to prove by preponderance of the evidence, and she would need to find some fault. What would happen is if you didn't have fault, they would probably find something to make up at least to fit in this, and it would probably go into cruelty.
Cruelty.
And you would say, oh, they were cruel, and you would try to make it fit those facts so that you could get divorced.
Maybe, so an expert would probably have to prove.
Yeah,
that,
you might have an expert, and you would definitely have to put on testimony. It's not going to prevent anybody from getting divorced.
Right.
People are going to still get divorced. What it's going to do is make the divorce process more complicated and more expensive.
While this woman is dying of cancer, now she has to prove that he's being cruel to her, and she has to prove the bills haven't been paid and all of this stuff.
Not only that, but the cost of litigation is really high. In this county, a baby lawyer is charging at $200 an hour. Most lawyers that are board certified are $400 or $500 an hour. In Houston and Dallas, it's even more. So the cost of litigation, if you have a relatively middle-class family, you can go through the entire estate just fighting a lawsuit like this.
Absolutely.
That's not good. Like, you want people to get through the process, keep their assets as intact as possible, keep their children out of the conflict, and move on with their lives.
Yes, ma'am. Thank you.
Members, any other questions for this witness? Chair recognizes Representative Cook.
So I appreciate the practicalness of your testimony today, and just wanted to ask you, do you think it'll have a positive impact or a negative impact if parents actually agree on the custody, possession, and support of their children, but they're required to go to court and have this knockdown drag out? Do you think that's going to have a positive impact or a negative impact on their ability to co-parent?
I mean, it's definitely going to be negative because you're looking for every little thing that you can use against the other person. You're going to be wanting to put them on the stand and then talk about every horrible thing that they've done. Think about what that does for co-parenting in the long term, which is one of the reasons why we don't even allege fault unless we have to.
Right. And so if parents are unable to co-parent, who loses in that situation?
Oh, the child. And sometimes parents could co-parent in the beginning, but after going through a really high conflict, highly contested case, they don't co-parent at the end.
Thank you.
Members, any other questions? Okay, thank you for your testimony.
Thank you.